Good evening, everyone. Thank you, Sangram sir, and thank you, Jayant Mahapatra sir, for setting the tone of this evening. Today, we are celebrating the 85th birth anniversary of Shri late S.N. Mudali sir, the founder chairman of National Institute of Science and Technology. And to this lecture, I welcome all of you. Shri Mudali, throughout his life, fought for the upliftment of the underprivileged section of the society, fought against corruption, and stood for equality, free speech, and economic stability. He was an educationist, a visionary, and a leader non parlance. On this occasion, we are extremely happy to have amongst us one of the tallest pillars of Indian journalism as the chief speaker. I would like to request Dr. Jayant Mahapatra sir, the former Vice Chancellor of Berhampur University, to please introduce our guest of this evening. Sir, please.
Thank you, Dipti Ranjan. Esteemed Mr. Ram, popularly known as N. Ram, but actually N should be expanded to Narasimhan Ram, Director of NIST, Sangram Babu, Madam Gitika Mudali. I think my best friend Ali Kishore is also has joined. Nowadays, he has become a Eid Ka Chand. He is the General Secretary of the Politburo of CPIM. So hardly I am meeting him. Otherwise, it was a meet every month virtually. Nowadays, hardly he meets. But I am happy that he is joining here. I welcome all the participants to this webinar or guest talk, whatever you call it, those who have joined, log in, have decided to listen to Mr. Ram. Introducing a person like Mr. Ram is sometimes very easy, sometimes very difficult. You can speak on towering personalities like N. Ram for hours together. At least if I go on speaking on him, at least I will need 45 minutes or so. Because I have been following him since my PG days, or maybe 1977, correctly. In 1976 August, I became a lecturer in political science. Before that also, I was following Hindu, and in 1977, I think, if I'm not incorrect, N. Ram joined Hindu as, I think, associate editor, or in some capacity he joined. And since then, he has not looked back. But one thing all of us must know. Nowadays, we are thinking of students doing journalism degrees. Students doing journalism degrees in different institutions has become a fashion. Everybody thinks that it is a professional course. If she completes a journalism degree, a job will be there. In Indian universities, the course journalism master program or a diploma program was started early. Then master program, it has a slow growth. But just think, N. Ram, as a brilliant student of Loyola College, of Presidency College, Madras, he didn't pursue any other course. But in those days, in 70s, he decided to go for journalism as a course to make his career. And from where he did it, from no other university than one of the best in the world, the Columbia University. From the Graduate School of Journalism, Columbia University, he did his graduation in journalism. After that, he has returned and he associated with his family business. This Hindu group, as almost all of you know, is controlled by the Kasturi Sons and Limited. Of course, NRAM is at present the chairman of the Kasturi Sons and Limited. They are the publishers of the Hindu group, whether Hindu newspaper or Frontline or Sports Star or Hindu Business Line. All this is published by that organization or institution. I will say that that has become an institution which has fought for investigative journalism under the stewardship of NRAM. NRAM came into prominence, I think, during the Bofors days. Many of you might be thinking that Bofors was exposed by Chitra Subramanian, or many people, many students have also asked me that Sir Arun Shri has exposed it as in Indian Express. But if you go to the archives of Hindu, then you will find that NRAM has a long or a huge contribution in exposing the Bofors scandal. And throughout his career as a journalist, as the managing editor, as the chief editor, whatever you call, he has tried to maintain his independence as a journalist. He has always respected the ethics of journalism. That is what is lacking today. What pains me most of the time when I read newspapers, I always try to read between the lines. I just don't read the lines written in the newspaper. I try to read between the lines. At times it pains me when I read some editorial or a feature article or a news story, how biased the reporters or the authors or the editors have become. They have sacrificed journalist ethics, but you will not find that with NRAM. NRAM, till today, very often I watch very sincerely, listen very seriously when he participates in any TV debate on very serious topics. Very often he comes in ND TV 24/7, and when I see it, I never leave it till the program is closed. There may be 4 or 5 guests on that panel. He will be sitting silently, speak very selectively, very precisely, to the point. But those few lines are the gist of that debate for me. And listening to him has given me a lot of knowledge. Thank you, sir, for making me more knowledgeable as a teacher, as a student of political science. NRAM has a glorious career. He is a Padma awardee. Government of India has given him Padma Bhushan award, I think, in the year 90 or 91, 1990 or 91. The most interesting thing is, Government of Sri Lanka has bestowed on him in the year 2004 or 5 the Sri Lanka Ratna, equal to our Bharat Ratna. Sri Lanka Ratna award has been conferred on him, the first Indian to receive it from Sri Lanka in the year 2004-5. The J.R.D. Tata award. Recently, 1 or 2 years back in 2018, sometime, I think, he was again awarded with the Raja Rammohn Roy Award. These awards are not awards sponsored by some corporate groups or something. Just like various TV channels are showing that we have been adjudged as the best news channel of India today. sometime India TV, sometime Mirror Now, sometime India Today. Others I don't see because I never consider the other channels as news channels. They are all news brokers. And I hate news brokers. So whenever I see Enram in any debate, it was so refreshing that I always try to remember what he has said. Sir, without your permission, your interpretations, your presentation in TV debates has been used by me as if that was my opinion in seminars and conferences or in webinars. You will excuse me for that. But once you are in the public platform, that is not your patent. So I have not violated any patent right. So I have used your interpretation many times. I am happy that Sangram could succeed in inviting you and you agreeing. As Sangram was telling me today when I inquired how we could manage to get Enram to spend time, I referred to Olikiswar's name. Sangram was gracious enough to admit that Olikishwar, my friend, has also helped him in your presence today for this webinar. With these few words, I welcome you, sir. I welcome all the participants, those who have logged in, and I am sure none of you will be disappointed for spending your time. Your time will not go waste. Whatever Enram says, please do consider that, listen that seriously, consider that seriously, try to analyze that and educate yourself. With these few words, I thank Mr. Ram for accepting the invitation of the National Institute of Science and Technology. I thank Sangram and the entire NIST family for giving me this opportunity this evening. Thank you.
Thank you.
Thank you.
Thank you,
So,
Professor.
Professor Ram.
Thank you, Professor Mahapatra, for those kind words and interesting remarks going beyond just a formal introduction. I really enjoyed that. And so it's an honor to be asked to give the 4th S.N. Mudali Memorial Lecture on the occasion of his 85th birth anniversary. And let me thank Professor Sangram Mudali for the invitation, and also thank my long-standing friend, Alikishore Patnaik, for introducing us to each other. The name Mudali rings a bell. It has a certain resonance for people like me, because it sounds very South Indian. But when I asked Ali about it, he said, no, they're very much part of the soil of Orissa. And he also pointed me to the area in which your sons of the soil. I never met the late Surendra Mudali, but I have read about him, the causes he fought for, upheld and championed, the institutions he helped build, the impression he left on everyone who came to know him or work with him. As a left student leader, as a lawyer, as a trade union leader, as a believer in Marxism-Leninism, as a defender of human rights, social justice, and democratic liberties, including freedom of speech and expression, freedom to organize and protest on just causes. He was obviously a multifaceted personality, editor and publisher, founder of major educational institutions, in particular the National Institute of Science and Technology, which has made outstanding progress as I read, Digant, a wonderful initiative, a residential school for children from poor tribal families where education is imparted free of cost. I learned recently about his writings in Janabadi, and I read 2 editorials which were translated in English, Preying on Mass and Media, And for whom is this independence? Evidently fearless, independent, outspoken, a voice of the people. He's also made his sacrifices. For example, during the emergency, and I read he suffered imprisonment, but came out undaunted. So it's an honor. It's a special honor to be invited, to be given this opportunity to speak on a relevant issue, an issue that surely connected with his interests, because it's all about rights, equality, developing your own abilities, standing on your own feet as a proud member of your society and your country. So that's why when I was asked what subject I would like to speak about, I proposed the politics of citizenship. I have worked and written on it for a while, and in fact, in a chapter in a book on citizenship published earlier this year by Aleph Book Publishing Company, I contributed this chapter. The lead essay was by the distinguished historian Romila Thapa, but for a more elaborate treatment of the subject, perhaps you can refer to that. There are also other contributors, Gautam Bhatia, the lawyer and constitutional scholar, Gautam Patel, a distinguished sitting judge of the Bombay High Court, and so 4 contributors. But mine is my contribution there was on the politics of citizenship in India, from which I can draw some of the material. What do we mean by citizenship? Historically speaking, citizenship is a modern concept associated with the rise of capitalism. Serious historians do not buy into the idea that in ancient Greek or ancient Rome or in our ancient India or ancient any country, you had citizenship. There were republics, there were active people, members of that society, but citizenship as we know it is a modern concept associated with the rise of capitalism. And Professor Romila Thapa's lead essay in that book on citizenship brings that out very, very lucidly. With independence and the framing and adoption of our Republican Constitution, there was a profound transformation of the status of hundreds of millions of people. And that transformation was from subjecthood to citizenship. It's quite obvious, but many people forget it when they use the word citizenship. A citizen is generally defined in the theoretical literature as a member of a political community who enjoys the rights and assumes the duties of membership. Enjoys the rights and assumes the duties of membership. The dimensions of this membership are broadly classified as citizenship, as legal status, defined by civil, political, and social rights, something that the late S.N. Mudali would have respected greatly, would have been deeply interested in. Secondly, citizenship as political agency, and citizenship as a source of identity and belonging. In other words, 3 classifications: citizenship as legal status, defined by civil, political, and social rights; citizenship as political agency; citizenship as a source of identity and belonging. Broadly, there are 2 models of citizenship. The Republican model, which is progressive, goes back, and the liberal model, which is somewhat different. I don't want to dwell on it today, but just for your reference. It's well recognized that the equality of all citizens endowed with equal rights is the foundational idea of citizenship as a modern concept and state of social being. The equality of citizens endowed with equal rights being the foundational idea. Here I quote Professor Romila Thapa, who brings this out very clearly, that lead essay I referred to. Citizenship is not always perfect. You had, after the American Revolution, citizens who considered themselves free and independent, But was it a perfect, an ideal concept and reality of citizenship? Obviously not, because there were slaves. Slaves had no citizenship, had no equal rights. They were considered chattel for white citizens to do as they wished with them, their lives, their women, their bodies, and everything about them. But over time, equality became a sacred principle, a supreme virtue. Likewise, in India, when we started out, citizenship was not a perfect concept because there was still untouchability, although the constitution banned it. There were still people belonging, scheduled tribal folk who lacked access to the rights that make citizenship meaningful. But over time, we have tried to close the gap between the ideal and the reality on the ground. So this must be understood right at the start, that the equality needs to be more than formal, that it needs to be real, rights-rich, and substantively accessible to every citizen, to every member of that society, which it cannot be in a society mired in inequality, exploitation, and oppression. That is a legitimate objection raised against the liberal model of citizenship. That's a weakness theorists see in the liberal model of citizenship. The Republican model is often seen as more progressive. But there are imperfections and deficits. But we need not enter into that arcane discussion here. It's important, but it can be left for further occasions, for scholarly discussions, for academic discussions. But on the other side, denying and subverting the equality of all citizenship in a formal as well as in a substantive sense goes straight to the heart of what we see as as injustice. And in this case, to the heart of what I would call Hindutva as an ideology and the Hindu Rashtra project as a political project. This, in truth, can be postulated, this denial of the equality of all citizens as Hindutva's foundational idea. It's a very specific criticism I make, and I'll come to that. It's not about, it's not an overgeneralized criticism, it's very specific, and I'll explain why. It would be trite to say that citizenship as a concept and as it is experienced on the ground by millions of vulnerable people has come under challenge, which is to say it has come under pressure, it has come under intimidation, it has come under threat, it has come under assault in this time. It is important to recognize that while the challenge to citizenship was ramped up after 2014 and became more aggressive and threatening after 2019, when the Narendra Modi government, the dispensation emerged with a strengthened majority in parliament, it is not an entirely new development. The parties that ruled before, especially the Congress party, bear a heavy burden for what came later. It is a process that has been incremental, and it is a process that has been developing over more than 3 decades at least. For context, I will take on board what I have shown in some detail elsewhere, and there are scholars who are much more learned and competent to speak on this subject than me. They have also shown it in detail, but I speak about my perspective. So for context, I take on board that the political history of citizenship in independent India, according to me, divides naturally into 4 chapters. I won't go into excessive detail, which may not interest everyone who's here on Zoom today. The first chapter begins with the making and provisioning of citizenship in part 2 of our Constitution at its commencement. And this chapter takes us to the enactment of the Citizenship Act, the first citizenship law for India. the history of India, and this happened in 1955. It was enacted in 1955. The second chapter turns out to be a relatively quiet and stable period for citizenship, 1955 to 1985. 3 decades, where it went very smoothly, relatively speaking at least. Chapter 3 covers the period from 1986, when the citizenship law is amended to make special provision for Assam in line with the 1985 Assam Accord. And that chapter extends to 2003-2004, when perhaps the most significant and far-going changes are made in the legal political regime governing citizenship. It's not in 2014 or 2019 that the most significant and far-going changes were suddenly made. It really goes back, if you read it carefully, if you read the evidence carefully, to 2003, 2004. And the fourth chapter, yet to be concluded, encompasses what has been happening since December 3, 2004, when the Citizenship Amendment Act of 2003, or CAA 2003, for which the foundations were laid in Chapter 3, came into force. That is why I say that was very significant. CAA 2003 put in place the legal framework for a new citizenship regime that was more arbitrary and more exclusionary than anything seen before, than anything intended by our constitution makers. Why the Congress-led UPA government notified, half a year after it came to power, such a major legislative change in the citizenship regime that had been enacted by the BJP-led National Democratic Alliance government, that is for the Congress to answer. But it does suggest incomprehension and confusion at the very least, but more plausibly, it reflects some degree of complicity with the illiberal and toxic project. However, the qualitative difference, or more accurately, the gulf between CAA 2003 and CAA 2019 must not be underestimated. Why? Because with the enactment and notification of CAA 2019, religion became an explicit marker, an explicit differentiator, a definitive basis for citizenship as legal status for the first time in the history of independent India. My criticism of what happened in 2003, 2004 is that it was more exclusionary and more illiberal, more denying than what had come before and what had been intended by our constitution and our constitution makers. But my criticism of CAA 2019 is somewhat different, because for the first time, religion became an explicit marker, an explicit differentiator, a definitive basis for citizenship as legal status. And that was for the first time in the history of independent India. And it was something that was actually prohibited by the overwhelming majority of the Constituent Assembly, the membership of the Constituent Assembly. If you read the Constituent Assembly debates on this question, it becomes clear. Not that everyone agreed on this. There were voices that resemble what we hear today, but they were very weak voices, came from very few in a different context, although it was a context that was very dark, context of partition, when millions of people lost everything, where their lives were dislocated, they were rendered homeless, many were killed, massacred. And in that grim context, it is remarkable that our constitution makers and the overwhelming majority of the delegates to the Constituent Assembly of India decided on this issue in a very creative way, in a very courageous way. So along with several constitutional and legal scholars, historians, political analysts, and public intellectuals, I have argued elsewhere that this political coup d'etat by the Hindutva regime is profoundly unconstitutional. This is not my original criticism. I share what many people have said, but I've also looked into it. That BJP regimes at the center and in states have sought to suppress the democratic protests and defend and enforce his coup d'etat with brutality, violence, and vengeful prosecutorial fury only underscores the anti-people and authoritarian nature of this project. Just look at what happened in Northeast Delhi in February of 2020. There's a great deal of writing on it. It's been well documented. See the vengeful prosecutorial fury, the injustice that has been done there. The lives lost, the property destroyed, the livelihoods destroyed. I don't want to say more about that chapter, but everyone knows that it was a global crisis of the COVID-19 pandemic that pushed this major issue of newspaper front pages and primetime television news to the very margins of politics. But the issue which threw the light on a canker in the heart of the body politic will not go away. At its heart is the question whether this authoritarian Hindutva project can be allowed to trump the secular character of the Constitution that forms part of its basic structure, as the Supreme Court has held in its famous or celebrated basic structure judgment that proclaims the basic structure of the Constitution and gives examples of it. The contentious issue relating to citizenship and religious identity that was brought up in the wake of partition but got nowhere in the Constituent Assembly debates, an issue that Jawaharlal Nehru, our first Prime Minister, derisively described as a little thing, dust in the pan, it became a very big deal in 2019-2020. The big deal, it became clear, had four separate but interrelated political components. One, the provocative and polarizing enactment of the CAA 2019. Two, the mass upsurge against it, seen in tandem with the National Register of Citizens and the National Population Register across much of the country, not everywhere, but covering a large part of the country. Thirdly, the repression and violence unleashed on the protesters by both the state and gangs of bigoted thugs. And four, which is not often flagged, the potential crisis of federalism manifested by tensions and a possible showdown between several states and the central dispensation on the citizenship question. And I think most states, including Odisha, have problems with this nexus between the CAA, the NRC, and the NPR. I don't want to get into details unless there are questions. I shall not go into the constitutional and legal aspects of this major challenge to the idea of India in any detail. I shall adopt, for my exploration of the politics of citizenship, the following argument presented succinctly and elegantly by the lawyer Mihir Desai in a February 2020 article published in the Economic and Political Weekly. I've referenced it in that chapter in the book I mentioned. The CAA, he says, is unconstitutional. Even if it is held to be constitutional by the Supreme Court of India, the opposition to it is justified and should continue. If the CAA is held to be unconstitutional, the NPR and NRC must still be opposed, since they are exercises that will be extremely detrimental, especially to the poor and the marginalized, for whom the person whom we are memorializing today deeply cared all his life, in many chapters of his life. I'll only add that lessons need to be learned from the updating of the original Assam NRC between 2013 and 2019. That exercise that proved to be a nightmare for millions of the state's residents should serve as a warning to the rest of India on what a countrywide NRC implemented by a surveillance-oriented and illiberal regime would turn out to be for hundreds of millions of people. Whether the Congress does it or the BJP does it, it's still a huge burden on people, and especially for millions of the poor and the marginalized. Those who have supported it have spoken in different voices and contradicted themselves on the question of how the population register relates to the register of citizens, and also to the 2019-2020 changes to the citizenship law. But my answer is simple. The National Population Register has no purpose other than to serve as the basis, the data source for the National Register of Citizens, NRC. The NPR, the National Population Register, is a register containing details of persons usually residing in a specified locality, which may be a village or a rural area or town or ward, a demarcated area within a ward or a town or urban area, and the specified particulars relating to each family and individual residing in a local area, including the citizenship status that will be collected through house-to-house enumeration. The National Register of Citizens is purely an administrative exercise which feeds off the population register, and it will be built up from below, from the local through the sub-district up to the through the district and through the state up to the national level. The process provides, it's true, for verification, for publication of a draft local register of Indian citizens, going all the way up, the filing of objections and appeals. But the power given to the local registrar to enter remarks in the population register, if he or she feels that the citizenship of an individual is doubtful, this will be a Damocles sword hanging over the heads of millions of people. And you can imagine the troubles it will create. The authoritarian nature of the NRC project becomes clear from a plain reading of the 2003 amendment to the Citizenship Act and a plain reading of the Citizenship Registration and Citizens and Issue of National Identity Card Rules 2003, framed under that amended law. Lawyers especially will be able to appreciate the significance of these rules framed under the law. Viewed in combination with the two other citizenship-related projects, an amplified NPR exercise and the threatened countrywide NRC, CAA 2019 poses a direct challenge to India's democratic and secular polity and to its political stability. No timeline has yet been set for the implementation of the All India NRC, which has, on the other hand, the fieldwork of updating the National Population Register except for Assam, alongside phase 1 of Census 2021, was notified for implementation in all states and union territories between April and September 2020, but it was unavoidably postponed until further orders. A few BJP leaders have been giving vague hints that the implementation of the NRC, evidently in tandem with CAA 2019, will be taken up after the pandemic is over or is brought under control. Whenever that happens, the ruling party will find itself walking a tightrope in Assam, where the NRC as an exclusionary project causing immense harm to the lives and livelihood of millions of poor, marginalized and vulnerable people originate. That's where the NRC originated, and the ruling party in that state and at the national level will find itself walking a tightrope on this issue. Let me now very briefly, I don't want to go into excessive detail, sort of scan the overall scene and look first at the origins of inclusive citizenship in modern India. If only to compare and contrast that chapter with what is happening in India today. The story begins with partition, which was independence's twin. It suddenly inserted the citizenship question into the proceedings of the Constituent Assembly of India as a set of problems to be tackled urgently. Before partition impinged on the work of the Constituent Assembly, citizenship was not much discussed. The matter was extensively and passionately debated, and the citizenship provisions in Part 2 of the Constitution of India became operative at its commencement. So when did what is the date of the commencement of the Constitution? It's November 26, 1949, although the Constitution was adopted a little later. Politically speaking, these constitutional provisions, based on the legal principle of jus soli, that is citizenship by birth, are remarkably democratic, remarkably secular, remarkably inclusive, given the historical circumstances. That's something Indians can be proud of. That's something Republican India will be always proud of. Their implementation may have been flawed, deviating at times from the spirit of the provisions, particularly Article 7, but also Article 6, but never defying the letter of the Constitution, because this Constitution is resolutely opposed to using religion as a marker or religious difference as a basis for citizenship. So who is a citizen of India? The Constitution does not attempt to even define citizenship, but what it does very smartly, very intelligently in Part 2 is to answer the question, who is a citizen of India, and make provision to cover different categories of persons who are or shall be deemed to be citizens or are eligible to apply for citizenship after fulfilling certain specified conditions. Politically speaking, Article 5 matters more for the simple reason that it covered 98% of India's 1951 population of 361 million. So that was extraordinarily inclusive. Whoever was born or had other claims by being born in India, I think was covered as provision, Article 5. The article declares in one sweep that every person who at the commencement of the Constitution has his or her domicile in the territory of India and was born, or whose father or mother was born within the territory of India, or has been ordinarily resident in the territory of India for no less than 5 years immediately preceding such commencement, shall be a citizen of India. It is hard to imagine anything more democratic and inclusive than this provision based on the jus soli principle. And it contrasts with all that we see around in our own neighborhood, the policies they adopted towards citizenship. I don't want to go into the problems that arose with regard to millions of people covered by Article 6 and 7. And indeed, some members of the Constituent Assembly argued that preferential treatment should be given to Hindus and Sikhs, because neither the Hindu nor the Sikh has any other place in the wide world to go to, but the political leadership, backed by an overwhelming majority of the Constituent Assembly, decided there was no question of making religion a basis for citizenship. And there is a very famous authoritative assertion by the jurist Alladi Krishnasamy Iyer on this point, which I don't have the time to read out, but it's very, very significant that that we are plighted to the principles of a secular state and so on. Today, Article 7 seems dated, virtually a forgotten part of our Constitution. And even during the early years of the Republic, its practical effect may have been to benefit only a few thousand Muslims who had returned to India to reclaim their lives, their livelihood and their property. But it does subsist in the Constitution, a reminder of the kind of republic the framers of the Constitution had in mind and which we have deviated from over the decades. I don't want to go into the laws, the Citizenship Act of 1955 in any detail. It's fairly simple and straightforward law, provides for acquiring citizenship in 5 different ways: by birth, by descent, by registration, by naturalization, by the incorporation of territory. That happened with Sikkim. This takes the secular and inclusive approach forward. The law can be criticized for allowing the executive, the central government, too much discretionary power to determine and certify the citizenship of persons whose citizenship is in doubt, and also to deprive certain categories of citizenship on grounds that include purported disloyalty or disaffection by act or speech towards the Constitution of India. But too much should not be read into this, because this is very rarely invoked. In any case, it is not beyond constitutional and political challenge. In the main, India's first citizenship law, as originally framed, is entirely consistent with the approach taken by Part 2 of our Constitution. But with Assam 1985-86 and Section A, which was introduced to the Constitution, we take a new turn. The story takes a new turn. The story that begins with partition and the Constituent Assembly debates, takes a new turn because restrictive and exclusionary elements of jus sanguinis, that is citizenship by descent, intrude into the citizenship regime. The application of these features of the amended law is confined to Assam, where a violent agitation on the so-called foreigners issue has forced the hand of the government, leading to the Assam Accord. The amendment, however, carries a broader political message, although it's confined to Assam. Assam may be treated as a special case with regard to the legal challenges it brought about in India's citizenship regime. There's a substantial literature that has developed on it, that have framed the citizenship question, the foreigners issue, militancy, and what rights-based democratic citizenship would entail in Assam and other states in the Northeast. Most political parties, it must be noted, have accepted the insertion of Section 6A, that is special provisions as to citizenship of persons covered by the Assam Accord in the citizenship law. It's not in the Constitution, the citizenship law, as being in the interest of peace and stability in the frontier state. But there is no getting away from the fact that 6A anticipates significant closures on the right to citizenship. Section 6A cannot be blamed for the thinking behind the CAA 2019, which for the first time in the history of the Republic makes religion a basis for giving citizenship to migrants, illegal migrants as they're originally termed. But the idea of the foreigner, the illegal migrant, the infiltrator, and external aggression and internal disturbance taking place on account of large-scale migration from Bangladesh takes birth in the cauldron of Assam's troubled politics. And even the Supreme Court of India was not above using emotive and prejudicial language against those who had, after all, been residents of Assam for many years, and in many cases for decades. The prolonged nightmare of Assam's NRC first saw 4 million people, and in the final draft, 1.9 million people left out. It casts a dark shadow over the legal status, the fundamental civic and political rights, and the future of millions of people who live in the state, including those who are born and raised there. And here, the role of the Supreme Court of India under the stewardship of Chief Justice Ranjan Gogoi, turning itself into an executive court, directing, micromanaging, implementing the NRC, updating, and reviewing its own implementation, often in secrecy through a jurisprudence of sealed covers and confidential reports. This has been insightfully analyzed and criticized by constitutional lawyers, particularly Gautam Bhatia. But at the heart of this somber tale, which is actually a kind of modern day morality play, is the most fundamental of all sets of questions for a secular and democratic republic. What is citizenship? What is the stuff of which it is made? What are its qualifying conditions, both necessary and sufficient? And finally, what are the differentiae, a legal term allowed by the Constitution and the law and employed by the state to decide who is and who is not a citizen, and who can or cannot be a citizen through a qualifying process based on the principles of equity and justice. The answer lies in politics, in the evolving politics of the BJP, and going beyond that, in the communal authoritarian ideology and politics of Hindutva and the project of Hindu Rashtra, and in the politics of the enforcers, the Sangh Parivar, guided and controlled by the RSS, targeting the undesirable alien as a burden, an affront, as a threat to the nation, Bharat Mata, and to its purported unitary and defining culture, an idea pithily expressed in the slogan, "One nation, one people, one culture." This has been an important part of the stock in trade of Hindutva politics over the past 3 decades. The leadership has varied, but the project remains the same, essentially the same. The undesirable alien in the eyes of the Sangh Parivar and the BJP has long been the Muslim illegal immigrant, often called or termed the infiltrator, as distinct from the Hindu illegal immigrant, who is presumed to be something like a refugee, and by a virtue of his or her Hinduness, a desirable prospective citizens. For pragmatic political reasons, and in order to isolate Muslims, Sikh, Buddhist, Jain, Parsi, and even Christian illegal migrants have been brought in to make up a sort of addendum to the list of desirables. Successive central governments have admitted that no reliable data exists on the number of illegal migrants spread across the country who have made or have sought to make India their permanent home. Numbers such as 15 million, 17 million, 20 million, and even 25 million have been bandied about in the political marketplace, but no one seems to have a real clue about the scale of the migration that has surely occurred over several decades, absent any serious effort to regulate or control the inflow. A very large number of these, and this is important, of these immigrant families have children and even grandchildren brought in India who have not set foot on foreign soil. So going by the principle of jus soli, which was in the main the basis for citizenship at the commencement of the Constitution, they are or should be citizens by right. Many countries recognize jus soli, even today. Even a citizenship regime that combines elements of jus soli and jus sanguinis, that is citizenship by birth and citizenship by descent, but an even-handed, non-discriminatory way, is anathema to the Hindu right. India, by this test, is no longer the republic that was envisioned by those who gave it its constitution 7 decades ago. But for the rulers, the real problem lay in West Bengal, Assam, and to a lesser extent in other states of the northeastern region. According to data collected during the census of 2011, Muslims constitute 27.01% of West Bengal's population of 91.28 million at that time, and 34.22% of Assam's population of 31.21 million at that time in 2011. In essence, the BJP's allegation is that in these states, in particular, the vote bank politics of the Congress, the left, and other parties that it characterizes as pseudo-secular had seen to it that large numbers of Muslim infiltrators, as distinct from Hindu refugees, were enrolled as voters over the decades. And that's a very strong political motivation that has been driving these changes in the citizenship law and the citizenship regime. How to resolve this long-standing, and in Sangh Parivar eyes, this long festering problem of the legal status, political role, and future of the undifferentiated mass of illegal immigrants. Nobody knows the size, but we know that it is a very large number. So how to implement this solution? The solution worked out in principle by the BJP 3 decades ago, which it could not implement at that time, was depriving the infiltrators of their franchise as well as their citizenship, and detaining and if possible deporting them while protecting and embracing the refugees as prospective citizens. That was the solution worked out. But how to implement the solution? Two things stood in the way. First, the secular constitution and a citizenship law that stubbornly remained religion blind, notwithstanding the exclusionary and illiberal changes made to it in its installments from 1985. Second, mass political sentiment in Assam, which wanted all foreigners expelled, regardless of their religious identities or affiliation. Finding a way past these obstacles became a major political obsession for the party that now rules India, and this is reflected in the party's general election manifestos from 1989. The final solution arrived at was the National Register of Citizens and its byproduct, a national identity card for all citizens that would make biometric verification and digital surveillance possible. A study of the BJP's general election manifestos from the mid-1980s to 2019, which I've attempted, is revealing. In my chapter in that book, which I referred to, I've analyzed in detail what successive BJP manifestos for Lok Sabha elections from 1984-85 to 2019 have had to say on citizenship. The manifestos use emblematic code words, refugees on the one hand and infiltrators on the other, to differentiate between non-Muslim and Muslim illegal migrants who are said to have come across from the border in very large numbers from Bangladesh. The manifestos propose ways and means to tackle the problem: barbed wire fences, detection of infiltrators, deletion of their names from the voters list on a war footing, steps for their deportation, issuing identity cards to all citizens in border states, creating a special cell for identification of the landed properties acquired by infiltrators, confiscation of such properties. The National Register of Citizens makes an early entry in these manifestos, followed by a national identity card. Although the BJP's 2014 election manifesto makes no reference at all to an NRC, there is a hint of what is to come very soon. And I quote, "India shall remain a natural home for persecuted Hindus, and they shall be welcome to seek refuge here." This is by adopting a fiction, saying that anyone who's not a Hindu who comes across, who's not a Hindu or Sikh or Jain or Parsi, who comes across to India, across the border, comes because they fear they have been persecuted or fear persecution. And any Muslim who comes in, any Muslim illegal migrant who comes in to India from across the border is presumed to have come for economic reasons, which is not permissible under the citizenship regime. So this is the fiction that has enabled what was to come very soon. There was a new edge in the ruling party's approach to citizenship in the 2019 Lok Sabha election manifesto. There's been a huge change. The manifesto declares in the cultural and linguistic identity of some areas due to illegal immigration, resulting in an adverse impact on local people's livelihood and employment, will expeditiously complete the National Register of Citizens process in these areas on priority. In future, we'll implement the NRC in a phased manner in other parts of the country. So 2 years into its first term, the BJP, the Modi dispensation, had found a Hindutva way to resolve this long-standing problem of the legal status, political role, and future of an undifferentiated mass of illegal, what they call illegal immigrants. The solution would be based on religious difference, with a red line drawn in the citizenship law against Muslims. For the first time in the history of the Indian Republic, as I mentioned earlier, religion would be a basis for citizenship as legal status. And I've already mentioned that it was justified by adopting a certain fiction. To implement the solution, the rest is obvious. a Citizenship Amendment Bill introduced in the Lok Sabha in July 2016, referred to a joint parliamentary committee, adopted by the lower house in January 2019. The bill could go no further because the government did not have a majority in the Rajya Sabha at that time. Not to be thwarted, the BJP committed itself in the 2019 election manifesto to enacting the amendment for the protection of individuals of religious minority communities from neighboring countries escaping prosecution. I'm quoting from that manifesto. So as for Assam, the manifesto promised to make all efforts to clarify the issues. It basically dodged the issue because in Assam, they wanted all so-called foreigners to be denied citizenship. So it had a real problem there, and that problem remains. What is clear today is that the change in the law will have major political implications, not just for the so-called illegal migrants, not just for large numbers of victims or the presumption of non-citizenship that is becoming entrenched in the legal, administrative, and political system, but for all Indian citizens, and especially for the country's 210 or so million Muslim population. It's not a small population. India is one of the largest Muslim populations in the world, I believe the third largest, and it will have serious consequences for citizens precisely because by subverting the principles of a secular state that found resonance and prevailed in the Constituent Assembly debates, this poses a threat to constitutional morality as well as political stability. Apart from this, a countrywide NPR, NRC process will have the effect of causing tremendous hardship and harassment to millions of the poor, the dispossessed, and the marginalized, drawn from all communities, because considering that at some stage, documentation that is simply not available or is not easily available will be required to prove claims of citizenship. Political India seems to have figured this out, which in my view explains, at least in part, the breadth and depth of opposition to this citizenship project across the land. There are apprehensions not just among Muslims, although they are mostly affected, to be realistic. It remains for me to do two things before I conclude this lecture. First, to comment briefly on why a citizenship regime that began brightly, despite difficult, grim historical circumstances, with the making of a transformative constitution founded on the principles of justice, liberty, equality, and fraternity, to quote from the preamble, has become the arbitrary, undemocratic, biased, and surveillance-oriented regime that we encounter today. The answer is that the concept of equality of all citizens, endowed with equal rights and charged with duties, does have rich meaning and value. It continues to have rich meaning and value, especially in a multilingual, multi-ethnic, multi-religious, multicultural, multi-everything country. Sometimes it also poses hard questions. So in attempting to find answers to these questions, political India has clearly lost its way. The reasons for this are too complex to be explored here. It's enough to note that there have been huge democratic and governance deficits in handling citizenship aspirations and issues that have been articulated from time to time. Among these deficits are an inability to deal democratically and justly with internal contradictions, tensions, and conflicts, failure effectively to manage relations with the neighboring countries, especially those having common borders with India, opportunism in dealing with chauvinistic movements and tendencies, the unchecked advance of communalism as a political mobilization strategy, and the rise of strongman politics and its inevitable consequence, authoritarianism, and the weakening or subversion of institutions of democracy and state. Over the past 3 decades, political malafide, in this case, communal and chauvinistic intent, has triggered actions and policies that are deeply detrimental to the citizenship rights of millions of people living in the country's eastern and northeastern regions. So there has been an institutional failure of major scope and proportions. So what's to be done? As I pointed out earlier, the COVID-19 pandemic crisis has pushed these issues, as well as support to it, out of the frame of practical politics, at least for now. The pandemic has brought havoc everywhere, but it has also produced unexpected, one can even say unintended consequences. And one of the consequences has been to show up the limits of political power in all countries, in most countries. The 2019-2020 mass protests against CAA 2019, seen in tandem with NRC and NPR, those projects, and the farmers' agitation of 2020-2021, which has shown remarkable resourcefulness, resilience, and staying power. These have demonstrated that there can be effective democratic resistance to authoritarianism and anti-people policies and toxic projects. The outcomes of the 2021 Legislative Assembly elections in West Bengal, Tamil Nadu, and Kerala have demonstrated that while communal polarization, combined with the manipulation of state agencies such as the CBI, the Enforcement Directorate, and the Income Tax Department, and even the constitutionally provisioned Election Commission of India, while all this can yield some political mileage, authoritarianism and its toxic projects can be effectively resisted, opposed, and pushed back, given especially the enormous diversities that characterize India. That is our strength. It is not a weakness, the diversity and pluralism of India. Indeed, the social, economic, linguistic, ethnic, religious, cultural, and political diversities of India, and the semi or quasi-federal nature of its policy, however much authoritarianism in centralizing overdrive seeks to subvert this basic feature of the Constitution, this must be recognized and brought to the fore as valuable democratic assets. In quite another sense, the pandemic and the catastrophic handling of it by the Union government do have implications for strongman politics. As an article in the New York Times pointed out, not just about India, quote, "The virus cannot be arrested, censored, or outlawed," and reverting to the strongman's standard playbook and employing a mixture of propaganda, repression, and ostentatious shows of strength to exude an aura of total control is a risky strategy for an inherently chaotic situation. So the COVID-19 pandemic, of course, it has brought immense suffering and losses to the people of India. But the failure of authoritarianism to respond to this unprecedented challenge scientifically, rationally, systematically, without fake triumphalism and vaingloriousness, but with genuine concern and abundant practical support for the lives, livelihood, and health of hundreds of millions of India's vulnerable citizens. This has brought national and international disrepute to the regime. But one of the unintended consequences of this crisis has been to show to advantage, as I noted earlier, the resilience, the virtues, the benefits, and the power of democratic citizenship when it is vested with civil, political, and social rights, as well as with duties and responsibilities to the common good. By their individual and collective actions, citizens exercising political agency can strive not just to cope, but actually to find a way forward. And we can do it. When the situation returns to some kind of normalcy, citizens can, in an organized way and with support from democratic political parties, seize the initiative. They can put rulers, including strongmen, in their place, and they can pick up the issues that matter. So these are the issues, these are the questions that the person we are memorializing today would have had a lot of time for, would have taken a deep interest in, and given his courage and his spirit, would have spoken up on. And it is my honor to have given this lecture today. Perhaps I've taken more time than was intended by most, Professor Sangram Mudali, but I thought these are important issues that can be presented before a serious audience. And thank me for the honor and the opportunity.
Thank you, Shriram. This has been the most, I would say, you have in your talk absolutely hit the nail on the head, and clarified not only the issue of citizenship, but all the possible pushbacks that any decent citizen of this country ought to do in this authoritarian regime, which not only is encompassing citizenship, but freedom of expression in academia, freedom of expression in cartooning, in movies, in threats of publishing, and in fact, the entire intelligentsia's work throughout across the country in different religions and spheres. I would just like to, before I throw the room open for a few questions, which we will take, just on the issue of Rohingyas, I would like to know from you, the Supreme Court has possibly issued a pushback order to the extent that the Rohingyas on a humanitarian cause may be taken inside. But how does it work with the executive, and what exactly is the status now?
Yes, I think that's a very interesting question and an insightful question. And I see some encouraging signs with the Supreme Court, now presided over by Chief Justice Ramana. It has done some very good things. Many of us were disappointed with how the citizenship question and the NRC had been dealt with earlier. And also on the question, we were shocked by the attitude the executive adopted towards the Rohingyas in particular. Where would they go? Are you pushing them into a genocidal situation? And it is good that this pushback is there, but it's a small thing. And I hope that the Supreme Court will not give in on this, because if you see how the Solicitor General of India normally responds to these issues, I don't want to say more because it's quite shocking. And I think the time has come to really protest against this, the kind of intimidating tactics that are employed, not by the Attorney General. I want to make that very clear. He's my old friend. He doesn't do these things, but the Solicitor General, repeatedly, his comments have been reported in the press, his partisanship, the position he takes. So it is a question to which there is no clear answer, but there are encouraging signs. And I do hope that the Supreme Court will insist, just as it insisted on this ex gratia payment for those affected, a very recent judgment or order. I think, I hope that it will insist that the executive implements and obeys this and similar orders. Because there is a pushback from the executive as well, and there's a certain disregard for the rule of law that is very apparent in this time of Hindutva, which needs to be done. Even when somebody, in order to release somebody, it doesn't get done instantly or immediately, the way it should in a country that is under the rule of law. But I see signs of hope. I hope I'm not reading too much into them, but this, I think, is very symbolic of human rights, for which your father did a great deal. The weekly magazine was started. It's a human rights. It wears that on its sleeves. Human rights, the human rights of Rohingyas. At this time, at this very dark time in Myanmar. But thank you for that question. I think we need to study this. Yeah.
Mr. Bhavani Pani, you had a question? Bhavani? You can unmute yourself. Arnab, please unmute Bhavan. Yeah.
Mr. Ram, thank you so much for bringing out the negative side of CAA and NRC and all this. But you see, isn't it necessary for India, for a country like overpopulated country like India, to protect its present population from the infiltration of, I won't call it Islamic jihadis, who are being pushed from across the border into the country, and identify and India is not the only country which gives identification on the fingerprints mapping and a citizenship card in addition, where your passport is only for traveling for across the border, but proving your citizenship is your biometric card, like your Aadhaar card. What's wrong with it? That's my question.
Yeah, I think this this needs a very complex and detailed answer, for which we may not have time, but I'll indicate my thinking on it. You have failed to stop this inflow from across the border completely. And it's not, a large number of people come for complex reasons, have come across the border. And of course, a lot of it happened earlier after 1971. So it is possible that some extremist elements may come in, but they need not necessarily be just Muslims. That's because you have extremism, you have Hindu extremism as well. What we are in particular, my first objection is you're making a distinction between Muslim and the rest. And of course, this plays to the propaganda on jihad and so on, love jihad and so on. If it is true there is jihad, but it is also a toxic Hindu extremism in the name of Hindutva. Not necessarily Hindu. Hindutva must be separated. It's a political project. It's not a religious project, identity. As Savarkar and Hedgewar, everyone has made clear, Golwalkar and so on. So the way to tackle extremism is not to resort to communalism, not to resort to religious differentiator between those who have come across and those who have been born. Their children and grandchildren are here. They've been born here. What jihadi offense can Muslims who are born here commit, unless you brand the whole lot? And then you should do it for 210 million or whatever numbers of people, because they come under suspicion. That's the objection. Even the Supreme Court resorted to vocabulary like that, extremism and so on, in one particular judgment. Unfortunate judgment, unfortunately worded judgment in any case. So it is true, perfectly true, that other states do it. Trump did it, and many other states have done it. It's not just an Indian question, but what we are dealing with is the Indian situation. So I began by saying the concept, can you imagine what would have been more deadly than partition times, when emotions were running so high, and many, hundreds of thousands of people had been massacred on both sides, when the situation was terrible. At that time, that's why I use that as a reference point, the starting point for citizenship. India, when did citizenship come about in India? No, it's not easy to date it, because when you became independent, you were neither subject nor citizen. Indians were neither subject. It was sort of interregnum, a no man's land, if you like, a no man's time. And then with the adoption of the Republican Constitution from its commencement, on that date I mentioned, citizenship is created, and it is inclusive. It is not based on religion. It is remarkably inclusive, democratic, generous in its scope. From that, you are now saying you're giving an open general license to the executive to say who's a citizen and who's not. These are the kind of objections that have been raised. And the objection is not to citizenship, documentation, a national identity card, and so on. It is to doing this in a context where documentation is virtually impossible. People do not have their birth certificates, increasingly going on. And how do they document their citizenship? It's not simply not possible in rural areas and so on. And many of these documents can be fabricated, can be created afresh through corruption or other considerations. So it's an enormous job on the ground. Eventually, yes, there should be documentation. I fully agree with that. But are we ready to do it now? And are we ready to do it in this manner, where there's a presumption of non-citizenship for those who have come across from the border who happen to be Muslims? That is the problem. And in Assam, you have a further complication, that they don't want anyone, Hindu, Muslim, whatever, any Bengali who's come across or who's believed or suspected or alleged to have come across, they don't want them out. What documentation can they produce? And even if they produce authentic documentation, it is rejected by these foreigners' tribunals, which have the last word on the subject. People die in those detention centers, starve to death. So these are the problems, the realities of India that have to be addressed.
Thank you. May I take Professor?
I'm sorry, a long answer, but it was a good and relevant question.
Sir, I wanted to ask you a question. I'm Shwetank Rajguru. I'm a NISTian. So nice of you explaining about citizenship and everything, really inspiring. Sir, my question here is, we are talking about a citizenship limited to a geography. How about citizenship globally? I'm talking about global citizenship, okay? When we talk about global citizenship, the major, the differentiating factor here is a religion. When we talk about global citizenship, it is not mostly the originate of the country, but it is, religion based on which all political parties, all countries keep dividing people. So what is your thought on global citizenship, where Hindutva is a major stake? If you see religion-wise, a citizen, as you rightly said, a section of people, those who are segregated based on their religion, and that is one form of citizenship. So you find that the Jains, the Christians, the Muslims and Hindus, if you take it consolidated wise, you will find most of them are either Muslims or most of them are Christians. What about other religions? Don't we need to protect that citizenship as well? What are your views on this?
I think you cannot use religion as a differentiator. That's my simple answer. It's not allowed constitutionally.
I think, Shwetank, if you go back to his talk, Ram has clearly said that religion is not a distinguisher, and our constitution is religion blind.
Sir, that is in perspective to India. I'm talking about global citizenship. That is why my question was very clear.
Yeah, yes. Okay. The global, there's nothing like global citizenship. You're talking about citizenship in other countries. In other countries, then many of them are secular. They're also theocratic states that where, of course, they allow minorities to become citizen, even Pakistan, but they don't have equal rights in many of those countries, because you can't, there is a hegemony of the majority, who in those countries largely Muslim. So we are not comparing India with Pakistan or Saudi Arabia or any of those countries. But even in those countries, there is a certain protection for people belonging to other religions who identify themselves as practitioners of other religions. But in most developed countries, although there is prejudice, racial prejudice, religious prejudice, bigotry, Trump right at the top in the White House was an example of that. He was very open about it, about what he thought of Muslims and so on. But their constitutions and laws protect what I would call equal citizenship. People belonging to all faiths, all linguistic groups, all color, people of all colors, and so on. There's no slavery in the United States. They can at most deny voting, access to the voting rights. They can try to restrict in indirect ways, in tricky ways, but they can't say that non-white is not, other things being equal, that a black person, an Afro-American or another person of color is not entitled to equal rights as a citizen. It's the same. The Constitution and the laws protect that. UK, France. So you must differentiate between prejudicial ideologies, discriminatory ideologies, and the rule of law and the Constitution in those countries. So in those countries, citizenship is protected in many cases much better than it is than in India today.
Thank
But
you,
I'm
sir.
not comparing with Pakistan and so on. Yeah.
Thank you. I think you have cleared the clouds, because your two wrongs don't make a right. Neither does one wrong make anything right. So by focusing on the wrongs, we have always tried to justify Hindutva. That I think you have cleared the doubts and the clouds. May I ask DP Das sir, he's the Vice President of the Odisha Bar Association, to speak a few words, because he had if there's any takeaways from this talk, or he would like to ask any question. DP Das sir.
Thank you so much, Sangram Babu. But putting question or formulating question is a very tough task than giving answer, I know. Because formulation of question is a very bigger task. But since I have got an opportunity to join, to get a distinguished chief guest of this occasion, Mr. Ram is there, and he is our virtual reacher also. Now I want to just, so far one question some Rajguru has put to Mr. Ram regarding the citizenship right, and that is the human being, that is the human rights, that is the rights. Between the two things are there, that is the human rights and citizenship right. Citizenship right, so far our constitution is concerned, to my bigger conception, citizenship right, it has been defined in our constitution. So far human rights is it has been defined in several legislation. So far other legislations are there. But my one question, since our guest, our distinguished guest is available, what is the concept of dual citizenship, and why dual citizenship it is not yet been accepted by our Indian government? That second, my point is that I need to be clarified, because supposing a person who is born in India and he has been immigrated to other states, other countries, and he accepted voluntarily their citizenship there, and as per our constitution mandate, his citizenship requires to be seized and here. Then why dual citizenship status it has not been considered yet by the government, or dual citizenship concept? What is concept of dual citizenship? If I think better, in a better way, Mr. Ram can define us.
Yeah, I think that's a good point, and I have no problem with dual citizenship. In fact, we should, as an emerging country, we should have been moving in that direction. And with the first the PIO card and then overseas Indian citizen, it was not real dual citizenship, as everyone knows, but it it narrowed the gap, or it was an attempt to narrow the gap. Today, I see them going back on it, because they can say that they can revoke the status of overseas citizen of India, and it is left purely to the executive branch. Although I presume you can appeal, you can go to a court to challenge that, but the executive has taken over. So I think for decades, India has been very suspicious. Politics in India has been very suspicious of this whole concept, or at least the rulers have been, because they think that patriotism or nationalism cannot go hand in hand with loyalty, shared loyalty, if you like, to another country. I have no problems with it because it would have been a very good thing if you had straight away gone for dual citizenship, because citizenship is not automatic. It has to be, you have to qualify for it, and there's a certain process. You could have worked on that process to make it appropriate for Indian conditions. But today, I think we see going back on whatever movement there was towards recognizing it, particularly for people of Indian origin abroad who have done very well and want to give back to the country. I think that was perhaps the motivating factor to bring about the changes in the citizenship law, about which you know better than I. But today, they're going back on it, and there is arbitrariness. That's the whole problem, I think. I don't know how many revocations there have been so far in these cases. We have no data on it. I don't anyway. But the power given to the executive to revoke this, because in my understanding, citizenship is irrevocable. And if it's quasi-citizenship or part citizenship, or citizenship in a manner of speaking, like OCI, then I think you can't take it back. For whatever reason, even a murderer does not lose his or her citizenship. Should not, because citizen is a member of a society, a political community. Your identity as a citizen cannot be taken away, just as the color of your skin cannot be taken away. So I think that's my approach, and I think I have the impression that you also favor the same kind of thing.
Thank you very much. On a lighter note, a lot of billionaires are becoming citizens of other countries, like small islands.
Yes.
So it's high time, I think, reverse migration of billionaires should happen.
You can buy
and in that case, dual citizenship would be okay.
I think it already exists. It already exists in some cases, because they don't reveal their passports.
May I request now Shri Alikishore Patnaik to kindly give a vote of thanks and mention a few words about his association with SN Mudali, with whom he had spent a very cherished time during emergency and otherwise.
Am I audible, please?
Yeah. Ali.
Yeah. Many thanks, Ram.
But we can't see you, Ali. We can't see you. Why don't you put on your video? Switch on you.
Yes. Now it is visible?
No.
Then I have some problem here, I think.
Okay. Then audio is fine.
My audio is fine, and I'm not that well versed with the computers. Anyway, so I'm really happy and thankful to Ram for delivering this lecture, beautiful lecture here. I heard him some 3-4 years back in Bhubaneswar in a meeting. He came here to address, and I had to run after Ram for a decade or so to bring him to Berhampur, which was not possible because of his busy schedule. And I think probably because of the pandemic, we are able to see him virtually now. So anyway, he is addressing a meeting conducted by Orissa institution, and that is one of the premier institute of our state, that is the NIST, National Institute of Science and Technology. And I feel very proud to be a part of this. Comrade Surendranath Mudali, I know him since 70s. My relationship, our relationship goes back to 1970-71. And we were together in jail, in Sundargarh jail, during internal security, under the Internal Security Act during emergency. And I was in Sundargarh jail. I was brought from Berhampur to Sundargarh. That was in the year 1975. I had a very memorable days with him in Sundargarh jail, and then after that I was transferred to Sambalpur jail. Anyway, so we worked together for a long time, and he was actually one of our leaders. When I joined the student movement in 70s, he was already a leader of the party, leader of the trade union movement in Rourkela. Not only in Rourkela, but all over the state he was known. And he was one of the leading figures of trade unions. So I feel privileged to be a part of this meeting and also to give vote of thanks. I am also thankful to Sangram Mudali, his son, and who is also very clearly vindicating his mind. And also he is very clear about many things of this, not only of the state, but of the entire country. And he is a serious thinker of the future of this country. So he is not only an entrepreneur, he is not only an educationist, but also a great thinker, like his father. So I feel myself privileged to be a part of this gathering. And probably this, again, I am to say, we could get Ram because of the pandemic. So I think he has come to Orissa 2 times. I think the last was 2016 or so, 15 or 16. So I'm thankful to him. I'm thankful to NIST. I'm thankful to Sangram Mudali. And I'm thankful to all of you who are watching him sincerely and listening to the thoughtful lecture of Ram, with whom my association with Ram goes back again to 70s during the student movement. We were working together, and then also he was our leader. And we brought him to Odisha and to Cuttack, I think in 1972. And he addressed as the Vice President of Student Federation of India. And we were together in Cuttack also. We were together in SFI Central Executive Committee. And I'm really very proud and thankful to Ram for sharing his views and also giving this thoughtful lecture on this day. Thanks to all, thanks to Ram, thanks to Sangram, and thanks to all the viewers who are participating in the discussion today. Thank you all.
Thank you. Thank you, sir. Thank you, sir, for an excellent talk. And we shall ever remember the 2nd of July, 2021, when we have done the impossible of bringing, as Ali Patnaik says, for a decade he tried to get you, sir. But we are very, very thankful that on my 85th birth anniversary of my father, you had the privilege of hearing you at the 4th memorial lecture. Thank you very much, sir.
Thank you, Professor. I really enjoyed this. Thank you.